Good morning.
Good morning, Your Honors. Mary Elizabeth McCullough on behalf of the state of Tennessee, who is the appellant in this action. This claim involves a claim for injuries that were sustained by a minor child at Chickasaw State Park in 2020. The Claims Commission found that the rangers at Chickasaw State Park were grossly negligent in maintaining one of the park's lakes, Lake Placid. This resulted in the minor child cutting her foot on a piece of broken pipe that was embedded in the lake bed. The state has submitted two issues for the court's consideration. First is whether the commission had jurisdiction to adjudicate the claims alleging gross negligence. Second, whether evidence presented at trial preponderates against gross negligence. I'd like to refer to the Claims Commission Act. The state is asking this court to review the statutory construction of the Claims Commission Act and specifically focus on whether the act allows for claims of gross negligence to be brought against the state. Our position, the state's position, is it does not, and the commission did not have jurisdiction to adjudicate this claim. Under the act, the state has waived sovereign immunity for monetary claims against the state in a limited number of categories. And those categories are described as acts or omissions of state employees, and they only use the term negligence when they're describing these categories or these actions of the state employees. The act does not contain the phrase gross negligence, except only recently. During COVID, the act was amended to include a Section J that addressed gross negligence and this addition indicated an attempt to distinguish between negligence and gross negligence. Prior to this COVID amendment, the only phrase used in the act was negligence.
Have you got any case law making the distinction that you're suggesting?
That there is a distinction between negligence and gross negligence?
The jurisdiction of the Claims Commission.
The jurisdiction of the Claims Commission has always been negligent acts of employees.
But do you have anything that says it does not have the authority to ascertain the gross negligence?
In the Lawson case.
Which was not a Claims Commission case.
Correct, but it's analogous in the sense of the Government Torts Liability Act removes immunity for certain actions of government employees for which the government entity will not be liable or will be liable, one or the other. And so it's analogous in this situation because the Claims Commission Act is very, very distinctive. It cites the categories, it talks about negligence, it does not talk about gross negligence of employees. And in other sections of the Claims Commission Act, it says that state employees can be reimbursed for loss or damage to their personal property within the scope of employment, but only if it was not caused by the employee's gross negligence. So the act does address gross negligence, but it specifically states that the state of Tennessee will not be liable for an employee's gross negligence.
What's the effect of the amendment?
The amendment is a separate Section J. And it says, notwithstanding any other provisions of this chapter to the contrary, the state does not waive its sovereign immunity for loss, damage, injury, or death arising from COVID-related actions by state employees, unless the claimant proves by clear and convincing evidence that the loss, damage, injury, or death was proximately caused by an act or omission of the state or an employee or agent of the state constituting gross negligence. So it specifically addresses gross negligence. There is another section of the Claims Commission Act that bars reimbursement by the state for civil damages awards against state employees if their conduct was grossly negligent, willful, intentional, or malicious. Otherwise, the Board of Claims will normally pay for final judgments against state employees.
Was this argument, the lack of jurisdiction argument, made to the Claims Commissioner?
No, Your Honor, it was not.
Okay. And the state asserted the recreational use defense, correct?
Correct.
So if your argument is correct, the end result would be the state can take advantage of the recreational use defense, but the plaintiff would not be able, assuming gross negligence were found, the plaintiff would not be available or have the opportunity to use an opt-out provision of the recreational use statute, correct?
That's correct, but a plaintiff who wants to bring a claim against the state and believes that gross negligence has occurred by a state employee could sue that employee privately. Quite often, claims that come to the Claims Commission are married with also private lawsuits, so that a plaintiff has brought an action against other co-defendants and the state. But of course, to file a claim against the state, you have to proceed under the Claims Commission Act. So if there was a situation where there was gross negligence, or in the progression of the lawsuit, it was discovered that gross negligence occurred, the plaintiff could then file a private lawsuit against the state employee for gross negligence.
Well, here the Claims Commission found it was the state that was grossly negligent, did it not?
Well, the state doesn't act except through its individuals, and it found that the park rangers were grossly negligent at trial. Yes, Your
So,
Honor.
It did not find any individual liability.
They
Was
cannot.
not asked to.
Correct. They cannot. Right. And this concept of gross negligence in this case was brought up at the motion for summary judgment stage. In the commissioner's judgment about denying the state's motion for summary judgment, the concept of gross negligence was raised at that point, and the claimant latched onto that and proceeded forth to trial with trying to prove gross negligence.
But it was not determined, it was a motion to alter or amend, I think, is where the trial or the Claims Commissioner found it. Is that accurate?
Correct. Because with the first judgment, he failed to address our affirmative defense of the recreational use statute, so he was asked to alter or amend the judgment, and at that point, he decided that the actions or omissions of the state employees constituted gross negligence. That was not the case with his original judgment.
But we're all, I assume you're in agreement that the GTLA law per se has no application in the Claims Commission.
Correct. The Government Tort Liability Act does not pertain to the state, does not apply to the state in this situation for these, the categories in the Claims Commission Act.
And what you're saying is simply by analogy, this court should look at Lawson and use the same analysis that the Supreme Court used as far as the GTLA, Governmental Tort Liability Act, regarding gross negligence, and apply that as a layer over the Claims Commission.
Yes, Your Honor, because when a governmental entity waives immunity, the statutes governing that waiver should be strictly construed, and that is what the state is arguing today, is that negligence is the only way that you can proceed against the state, except for that one exception that I spoke of earlier, to try and assert liability for actions of state employees.
Are you aware of any instances where the state's been found grossly negligent before in Claims Commission actions?
a couple of times. It's very rare, but there have been a couple of cases in which the state was found to be grossly negligent. And those were situations in which the employees knew of a dangerous situation and just absolutely failed to address it, mitigate it, or handle it in any matter.
Sounds like the facts of this case.
The facts of this case are Ranger Elder, who was the park manager, had been there for 15-plus years before this accident occurred. And during that time, he had never been given notice of this supposed dangerous condition. There'd been no report. There had been 4 different times that the lake, the specific lake that we're talking about, had been drained for either repairs or replacement of certain aspects. The fishing pier, they built a boat ramp. And there were 2 other times when there was repairs made to some other buildings that extended out onto the lake. And during those 4 times, during these 15 years, the lake was drained so that the repairs or construction could be undertaken. And during those 4 times, Ranger Elder testified at trial that there would have been inspections. They did not write the inspections down. He did not have a specific recollection of looking in that specific spot. But during those 4 times, the lake was inspected to ensure there were not hidden hazards that might be covered up by the water when it was, again, the lake was raised again.
Didn't the record reflect that there was silicone or something in that pipe?
Yes, it did.
How would that have gotten in there unless that had occurred when the lake was drained?
It's possible that that occurred before Ranger Elder's tenure there, but we don't know how the silicone got in there, why it was placed in there, who would have placed it in there. Now, the claimants are going to say that it could have only been state employees that put the silicone in there. Well, if that's their argument, then I would say that that mitigates against a finding of gross negligence, because apparently some kind of repair or covering was attempted to cover this piece of broken metal. But there is no
That's a nice try.
there is no evidence that any of the rangers were aware of this broken piece of pipe, and that's for the 15 years. Now, Ranger Elder also was asked some speculative, assuming questions. In other words, he had to make some assumptions. And his assumption was that state employees would have dealt with this particular area, this particular pipe, but he had no knowledge of that. He was just assuming that prior to his tenure, perhaps that's what happened. But there is no concrete evidence that it was a state employee. Even one of the times when the lake was drained for the building of the boat ramp, they brought in an outside contractor. So very often, outside contractors come in to do some of the work, the repairs or the construction in the lake. And I'd like to focus on the definition of gross negligence. It's a conscious neglect of duty or a callous indifference to the consequences of one's actions. There is just no evidence at trial that these rangers made some conscious effort not to inspect the bottom of the lake, not to look for hazards when the lake was drained. It appears from the commissioners...
Weren't they under a duty to do that?
And they did it.
Okay.
They did that. They inspected it every single time it was drained to ensure there were no hazards in the lake that could not be seen when the lake was full.
Well, what is the explanation for why it was not discovered?
No one ever saw it. No one ever saw the particular piece
But
of
if
pipe.
they're
Now,
But if they're doing an inspection to see if there's a hazard, but they didn't see it.
no, and the piece of pipe is close to the swim beach area, and I believe Ranger Elder testified that the water laps against the beach area, and it could have been that over decades, if there was something that covered up leaves, dirt, natural items I'm talking about, that they could have been displaced over time, and they just were never seen up until this girl cut her foot at the bottom of the lake.
All right, thank you. Well, here, I
Thank
don't
you very
recall
much.
if you've saved time for rebuttal. Forgive me, I don't, no, you
No,
didn't.
I did not.
All right,
Thank you.
thank you. We'll hear from the appellee. Good morning.
Good morning, Your Honor. May it please the court, my name is Edward Martindale, and I'm a member of the Madison County Bar Association. And I would like to introduce my associate who's been with me for some time. However, she does mostly divorce work, but she helped me with this case, and I'm going to ask that she be allowed to handle the first issue, and then I'm going to come in and do the second. I understand we only get 15 minutes total,
That'll be
but if
fine.
that's okay with the court, we'd like to do that.
Very
This is
good.
Jesse Snyder.
All right, Ms. Snyder, good morning.
Thank you, Your Honor.
Good morning, Your Honors. I'm going to run through this pretty fast because Ms. McCullough's already addressed and the court's already asked several questions, so I don't want to repeat myself and waste the court's time. But I do want to explain that this Lawson case that Ms. McCullough is referring to is a GTLA case. And that's specific in the finding in the Lawson case, Your Honors. And the Supreme Court specifically said that this definition of negligence, where the court states that it's just ordinary negligence, it doesn't encompass gross negligence at all, is only regarding the GTLA. It's only about the Governmental Tort Liability Act. Your Honors, if we were to take this definition of negligence and hold it as the same definition in the Claims Commission Act, then we would have no ability to ever overcome the recreational statute defense, Your Honors, because we have to prove gross negligence to move forward on that defense. And if we prove gross negligence, but gross negligence is taken out of the definition of negligence in the Claims Commission Act, then we would be proving something that we never could win to overcome a defense that the state has.
Sort of like the same situation in Lawson, isn't it?
It is, Your Honor. Yes, it is.
Where if you prove gross negligence in the claim, or excuse me, under the GTLA, you lose. But if you prove a lesser degree of negligence, you're successful.
Correct. But but the only way to get past the recreational use statute is to prove gross negligence. To overcome that defense that the state has, we would have to prove the gross negligence and then lose it because of the immunity from the Claims Commission Act.
Is there any question that the recreational use statute is applicable here?
No, Your Honor.
Okay.
And the recreational use statute applies to private owners as well, doesn't it?
Well, in this case, the recreational use statute applies to the state-owned property.
Well, it can apply to state-owned property, but it also can apply to privately owned property.
Yes, Your Honor. Yes, Your Honor. Absolutely. And I just want to end with one thing, and I think is very important, is Lucas v. State. And it's quoted in our brief, Your Honors, but it says that the Governmental Tort Liability Act is not and never has been applicable to the state of Tennessee regarding the Claims Commission Act, Your Honors. So to use a finding regarding the Governmental Tort Act in this case would go against Lucas v. State, Your Honors. And that's all I have. Thank you.
All right, thank you. Mr. Martindale?
Yes, Your Honor. Your Honor, I want to address, before I get into my argument, I want to address a couple of things that were said by defense counsel when she was up here arguing. First of all, she said that the lake was drained at least 4 different times, and every single time an inspection was made. There's no evidence in the record that that was done. Number one, Your Honors, there was absolutely, and I find it hard to believe, but there were absolutely no records that have ever been kept of any maintenance work, anything that has been done at Chickasaw National Park, according to park manager Elder, who has been with them since 2005, and he's been the manager of the park since 2014. As a matter of fact, in his deposition and at trial, he testified that he said, here's exactly what he said. He said, I'm confident that someone would have inspected the lake bottoms, but I don't know that for a fact. And there's absolutely no, there was no evidence anywhere in the record that this property had ever been inspected before. And when this pipe broke on the east side of, it was the closest pipe, I call it a pipe or a pole. It was the closest pipe to the seawall on the east side of the swimming area. On the west side of the swimming area, there was the yellow barrier did not reach all the way to the seawall. However, what the park had done, they took a turnbuckle and attached it to the yellow barrier and affixed it inside the seawall to where it was sturdy on there. The only pipe that was not was the pipe that was the lead pipe, the one that broke in this particular case on the on the west side of the swimming area. And I think that the reason that the pipe broke is because it had so much stress put on it. Anytime that moved, it was not affixed to the seawall. It was not affixed at all. In fact, they left about a 3-foot gap between the seawall and that particular pipe, and that's going to be important as well. But what happened is when that pipe broke, and one other issue, when the pipe broke, there was no what happened was when the pipe broke, the park manager said, "Look, let me tell you, I want this done, I want this fixed," and that what happened was, Your Honors,
Let me ask, a moment ago you said there are absolutely no records of maintenance work. But now you're saying when the pipe broke, the maintenance men did something. How do we know that?
Well, what happened, Your Honor, when the pipe broke, they saw that the pipe had broken. And park manager Elder testified at trial and in his deposition that when that happens, every single time it's anything involved with the swimming area, which particularly when a pipe breaks like this, that they are the people that go out and fix that, and nobody else. I know that defense counsel said that sometimes they have other companies come in and do this. Not in the swimming area. There's no evidence at all in the record that anybody had ever come out and done any work on the swimming area except the maintenance department at Chickasaw State Park. And that's what happened in this case. They came out, and when they went out, they saw where it had been broken, and what they did was they installed another pipe the same size as the rest of the pipes around the swimming area. And when they installed the pipe, they installed it directly about 1 foot directly away from the pipe that had broken. And what happened, Your Honors, is Excuse me, I just lost my train of
That's
thought. I
quite all right.
apologize.
Do you want to confer with your colleague?
I think, yes, Your Honor, if you don't mind.
Please.
Your Honor, I'm gonna let her finish this if that's okay.
That'll be just fine. Thank you for your
Yes, sir.
part of the argument.
Your Honors, you're exactly correct. There was no paper trail. There was no information showing anything that was done, anything that was fixed, any inspections that were made.
Then how do we know that whenever any pipe broke, the park employees did the repairs? How do we know that?
Because the park maintenance manager, Elder, testified that they handled everything regarding the beach and the swim area. They even installed a boat ramp right beside this area where the pipe broke. A couple of years ago, they restructured the beach and they did that. They all did that. They have track hose, Your Honor, that he testified that they can use when they drain the water down, and that everything was done. It's very evident when you look at the pictures that this pipe that was holding the swim barrier, Your Honor, that broke, is the exact same pipe, same width, same dimension, same everything. That was the new one that was installed, Your Honor. And you'll see that in the pictures in this case that were introduced into evidence at the trial.
So did he say that then that if there was silicone or whatever in that pipe, that would have been done by his employees?
That is the only person that could have that could have backfilled that broken pipe with silicone, Your Honor. Yes.
And the pictures that we have of the broken pipe, were they taken once the water was drained again after the incident?
No, Your Honor, they were not. There are two sets of pictures that are in the record in this case. The first picture, Your Honor, was actually one that was taken the day after this incident, where a flashlight was shined right into the water where you could see the pipe, and the picture was taken. It's not a real clear picture.
So the pipe is underwater?
It is, Your Honor. There's about this much water, about 5 inches of water on top of the pipe. But the problem is that there are leaves that come in that are over the pipe as well, because it's on the lake bed. It comes up about an inch from the lake bed. Around it, there's jagged pieces that come up, and there's another side of it that's almost flush with the lake bed. It's not just an even cut, Your Honor, over the pipe. So then, yes, there are more pictures where the debris is kind of moved over, and you can actually see the jagged pieces of the pipe coming out of the lake bed into the water, Your Honor. It's important to note that, and it was testified in the deposition even of Park Ranger Elder, the manager over the park, that when the incident happened, he informed his employees to go and fill this PVC pipe that was placed over this broken pipe, go fill it with concrete so that this doesn't happen to someone else. A year and a half later, Your Honor, we took depositions there at Chickasaw State Park, and Park Ranger Elder was asked, did you backfill that PVC pipe with concrete? And his answer, well, I told him to. I don't know. I don't know if it was done or not. And it wasn't. It wasn't done. This park was grossly negligent for creating this condition, for knowing about the condition, for installing a new pipe to replace this one that broke less than a foot away from it, Your Honors. To attach the swim turnbuckle to.
Now, you say the park created the condition. What evidence is there that the park created it?
Well, Park Ranger Elder testified that any maintenance done in the swim area would have been done by the park rangers and the park maintenance staff there in Chickasaw State Park. It's clear that this pole was there. It's clear that a new pole was installed. And based on Park Ranger Elder's testimony, it would have had to have been installed by the employees there at the park, Your Honor.
Could the old pipe have been removed when the new pipe was installed?
The old pipe, I don't know where the pipe went, the rest of the pipe. There was a remaining portion of the pipe at the lake bed, Your Honor. That was not removed.
And as I understand from the briefs, it was a jagged pipe,
Yes, Your Honor.
and it wasn't cut off or anything?
No, Your Honor. There was a jagged piece of the pipe. When our client stepped on the pipe, it was so jagged and so rusted that pieces of metal were in her foot, and she had to have numerous surgeries to keep getting the shards of metal out of her foot.
And that was allowed to remain when the new pipe was installed?
Yes, Your Honor. Yes, Your Honor. And it was also backfilled with silicone, just as Your Honor mentioned earlier. The old pipe was backfilled with silicone, which, again, Ranger Elder testified, if anything was done to that, it was done by his staff. It would had to have been done by his staff. But there's no work orders. There's nothing, no paperwork at all to show anything there at the park. They don't keep records of anything. That's why when we had a deposition and we asked Park Ranger Elder, was it backfilled with concrete like you asked for it to be? He said, well, I think it was. I don't know. There was no paperwork. There was no trail at all. So, Your Honors, just to sum it up real quick, it's our standpoint that the Lawson case does not apply, removing gross negligence from the Claims Commission Act, that the recreational use defense was enacted by the state, that we proved gross negligence. The court, Your Honors, in their order, specifically states in the second order where it talks about gross negligence that the park was negligent. They were grossly negligent. Your Honor, I've got it. Your Honors, we have it written out, and it just says that the commission finds claimant has proven gross negligence on part of the defendant. Gross negligence is an exception to the immunity provided by 77-102, the recreational statute. It does not limit the defendant's liability. That the state knowingly left a dangerous instrument, namely a broken metal pipe with a sharp, jagged edge embedded in the area of the lake that was frequented by swimmers and boaters, and it clearly rose to the level of gross negligence. Thank you, Your Honors.
Thank you. Your time is up. Thank you.
Yes.
Thank all three of you for your arguments. We'll take this matter under advisement. That concludes the morning docket.